Thank you very much, Fernanda. Thank you very much to the UN Working Group for having, for the very first time, a discussion on corporate capture at the UNBHR Forum. You're making history. It was about time. As Fernanda said, many of us have been working on corporate capture for several years already. And Manushya Foundation, based in Thailand, as part of ESCRNet, we have been working to document the manifestations of corporate capture. And I believe it's very important for me to remind what is corporate capture, because when we work with corporations or when we interact with corporations, often we realize that they do not understand what is corporate capture, simply because they have this feeling of entitlement and inherent right to interfere everywhere without being held accountable, while other human beings must be held accountable. So I'm going to provide you with some examples of what we understand by corporate capture and manifestation on the ground in Thailand and the impact that is being suffered by communities on the ground. So the first manifestation of corporate capture that I would like to share with you is community manipulation. Community manipulation under the name of fake consultations. And this is rampant. This is happening all over Global South, and in particular in Thailand, when there are development projects, coal-fired power plant, or any unsustainable development projects that are being developed under the name of climate action, or under the name of renewable energy, or under the name of sustainability. In Thailand, in southern Thailand, in the Thepa province, communities have been fighting against the construction of a coal-fired power plant because they have not been meaningfully consulted. They have been invited to meetings to be informed about the positive impact of the coal-fired power plant, mainly relying on job offers. They were never shared information about the negative impact on the environment, on the biodiversity, how they will be losing their livelihood, and how the traditional way of living and of fishing will be lost. Obviously, communities were against the plant. However, through the meetings held by EGAT, which is the Electricity Generating Authority of Thailand, a state-owned enterprise, and the consulting firm hired to conduct the environmental impact assessment, community were invited just to hear about the positive impact, but the signature on the list of participants were used as consent. So as a result of that, you have flawed environmental impact assessment and flawed EHIAs under the name of development project. Communities have been protesting against the construction of the Thepa coal-fired power plant. It's only in February 2018 that they started to protest in front of the UN to stop the construction. And when they protested in front of the UN, they were arrested for their peaceful protest because they were peacefully protested. They were slapped and they were found guilty for violating the Public Assembly Act. Just because they tried to denounce a flawed EIA, just because they tried to stop a power plant that is going to negatively impact on their lives and the environment. And community manipulation is not only happening in Thailand, it's happening in Laos, it's happening all over the world. And the people who suffer it the most are indigenous people, for whom FPIC is always being violated. The second manifestation of corporate capture I'd like to share with you is judicial interference. Judicial interference is happening when you have corporations unduly interfering on the judiciary process. So in Thailand, we are supporting a class action lawsuit in central Thailand, in Pradichit, central Thailand, where we are supporting more than 300 villagers suing a gold mining company for the negative impact they have been experiencing by gold mining operations for more than 20 years. So for more than 20 years, they have never received any compensation for the water being contaminated, for the negative impact on the environment, but also on their health. Several of them have lost family members due to cancer because of the water being contaminated and chemicals found in their blood. As a result of that, we supported them through a class action lawsuit that started in 2019. Each time, hearings of witnesses have been postponed. It's only in February 2023 that we're going to have the first ever hearings of the witness, because each time the company first used COVID as an excuse to postpone hearings, and then basically said that they didn't have enough evidence to be presented before the court. The Thai court allowed the company to postpone the case each time. We hope that in February 2023, we will really be able to hear the first witnesses. Even worse, in the very same case, the Thai government is under international arbitration because the gold mining company, Akara, is a subsidiary of Kingsgate, an Australian mining company, and they have been suing Thailand under the TAFTA, the free trade agreement between Australia and Thailand, because Thailand closed the mine at the end of 2016. So now Thailand is under the pressure of international arbitration. And because Thailand is under the pressure of international arbitration, operated by Kingsgate, launched by Kingsgate, Thailand renewed 4 licenses to reopen mining in Pichit provinces, knowing that communities still haven't received compensation and are still being affected by the negative impact of mining. And this is due to the pressure of the company. The other manifestation of corporate capture that I would like to share with you is legislative interference. And legislative interference is happening heavily when it comes to greenwashing policy. In particular now when companies are asked, to tackle climate change and to also implement the SDGs, especially SDGs 13. So in Thailand, we are witnessing the government being captured by companies and to pass greenwashing policy. And the most recent one that we saw just happened a few weeks ago during APEC 2022 and COP27. In Thailand, we now have a new policy. It's called the Biocircular Green Economic Model that promotes companies to invest in carbon credit under the name of reforestation and sustainable climate action, praising the accelerated implementation of the SDGs. However, in reality, what is happening in Thailand is that you have indigenous people and forest-dependent communities who are living in the forest that are being criminalized, jailed, arrested, and evicted from their land. Instead of being celebrated as protectors and guardians of the forest, they are being criminalized and they are being accused of destroying the forest. They are evicted from their land, and then what happens is that the government is giving the land to companies, for companies to invest in carbon credit so they can promote themselves as being part of sustainable development and as being part of the climate response. And this is very, very worrying because communities on the ground are the one paying the price of greenwashing policies. This is not just transition, and this is not sustainable development. This is actually an unfair and unjust energy transition when indigenous people and forest-dependent communities are put in jail under the name of carbon credit. Finally, the last example of corporate capture I would like to share with you is the corporate capture of the UN that is happening here in this very building. We saw already at COP27 that more than 600 fossil fuel lobbyists were there. And that's the reason why, as climate activists, we believe that COP27 failed to really find a solution to phase out fossil fuels. What is happening also here at the UN when it comes to business and human rights, there's also a capture of the UN. When we have the ICC and the IOE doing their best to weaken the negotiations around the binding treaty on business and human rights. We would like the corporate capture of the UN to stop. As Manushya, we are also part of the Feminists for a Binding Treaty, of ESCRNet, of the Treaty Alliance, and we want a strong binding treaty on business and human rights. We believe that National Action Plan on Business and Human Rights are not going to prevent corporate capture because weak and soft voluntary measures are not going to prevent corporate capture. We need binding voluntary measures. We need mandatory human rights due diligence, and we need a binding treaty that is strong. For that very reason, we want countries to really stop napping, and the only way that we can really prevent corporate capture is through a strong binding treaty that is not being captured by corporations. It's time for people and planet to be put over profit. Thank you. Thank you very much, Ananda. So reading the report, I selected a recommendation that I'd like to comment on, which is a recommendation related to the need to enact anti-SLAPP law, in order to protect human rights defenders. So I think, first I would like to comment the fact that the report does talk about the need to have mandatory human rights due diligence, because it's very important for the working group to say it clearly, and also the need for anti-SLAPP law to protect human rights defenders. So I'm very happy to see those recommendations. With regard to anti-SLAPP law, what could be done to make sure that such legislation are effective? I think it's really important for us to put into context the fact that even where there are existing anti-SLAPP measures, sometimes those measures don't work because of corporate capture of the judiciary. So we need to make sure that anti-SLAPP law does not allow for corporate capture of the judiciary. And I'm going to give you the example of Thailand. So you know Thailand enacted a National Action Plan on Business and Human Rights in 2019. Thailand praised itself that the NAP on BHR includes voluntary measures to protect HRDs. But because those measures are voluntary, obviously HRDs are still facing increasing SLAPP cases in Thailand with corporate capture of the judiciary and no justice to human rights defenders. Thailand also praised itself in the NAP that it has introduced anti-SLAPP measures in the Criminal Procedure Code. So in 2019, Thailand passed 2 amendments to the Criminal Procedure Code. One related to the bad faith of the case, of the plaintiff, and the other one related to the lack of merit of the case. So the first amendment 161/1 is in relation to it gives power to the court to dismiss the lawsuit if the lawsuit is in bad faith. The issue is this is not happening because of corporate capture of the judiciary. The second amendment that was brought up in the Criminal Procedure Code is 165/2, which actually gives the power to the defendant to provide more facts and evidence to the court, to the judge, to basically showcase that the case lacks merit. However, it's problematic because then the burden of the proof is on the defendant, on human rights defenders, who do not have the sufficient financial resources to submit a petition, to pay lawyers, and to provide additional evidence. So the anti-SLAPP measures that the Thai government praised itself with in paper look good, but in reality are not actionable, and they are not sufficient. And even when courts are given the power to dismiss the case in bad faith, when there is clearly bad faith because human rights defenders are just simply, for example, retweeting a tweet or tweeting about, like the case of Nada, our human rights campaign advisor, denouncing sexual harassment in the workplace on Facebook, they are facing defamation charges. So even when the court is invested with the power to dismiss the case, they do not do it because of corporate capture of the judiciary. So how can we make sure that anti-SLAPP measures are actually effective? First of all, we don't want amendment to the criminal code, especially in countries where we have an authoritarian government and where the judiciary will most likely not be independent. What we want a standalone, effective anti-SLAPP law. For example, there is the Texas Citizen Participation Act in the US that is really meant to uphold our right to freedom of expression, freedom of association, and the right to petition. So if you are a defendant and you're being sued by your company because you have denounced human rights violation or you have denounced abusive corporate actions, you can submit anti-SLAPP motion to dismiss and ask the court to end the lawsuit and ask the court to protect your right to freedom of expression, freedom of participation, and freedom to petition based on the act. You don't have, as a defendant, to prove that the lawsuit is in bad faith, and also it does not allow the plaintiff, so the company, to provide evidence to show that the case is valid. The second the Citizen Participation Act is being violated, the case can be dismissed. And I believe that in a country like Thailand, this is what we need. To have an effective anti-SLAPP measure or to have an effective anti-SLAPP law, we cannot give power to the company to prove that the case is valid, because when the judiciary is impartial, the judiciary and the judges are going to say that the case is valid. Also, we don't want any measures that put pressure on us, on human rights defenders, on the defendant, to bring more evidence to show that the company is in bad faith or to show that the case lacks merit, because it's additional burden on us, and it makes no sense to put additional burdens on human rights defenders. The goal is really to protect human rights defenders, and the only way to effectively protect human rights defenders is to have an effective anti-SLAPP law that upholds our right to freedom of expression, our right to association, and our right to petition any unlawful and bad and cases that is brought against us in bad faith, without having to justify it. Thank you. Okay, thank you. So most of the questions were not directed to me, thankfully, because I believe that most people in the room would agree with what I had to share. So in relations to technology companies and data privacy, I think that's the question I could address. Technology companies also have the responsibility to respect human rights. And they also, as part of being part of the business sector, they also make commitments in terms of implementing the UNGPs. They are part of the GNI, Facebook, Meta, Twitter, and other big tech companies also have the also make human rights policy commitments to implement the UNGPs and have their own corporate human rights policy. However, what we are experiencing in Thailand is more surveillance from governments, and governments that are purchasing and are buying surveillance technology, like in the case of Pegasus. In Thailand, Pegasus has been misused by the Thai government to surveil on human rights defenders. And now we have the first ever case in Southeast Asia of people who have been victim of the Pegasus software to actually sue the NSO privacy Israeli company for selling their product to the Thai government. So I think we need to remember that tech companies are part of the business sector, and so they also have to oblige, and they also have to implement the UNGPs. But again, the UNGPs being voluntary measures might not be enough. So we really need to go back to international human rights law, the right to privacy of citizens to be respected as well. And as a tech company, you need to make sure that you uphold data privacy and you don't give out the data of human rights defenders and of activists to governments just because the government asks for it. So it's really important that our right to privacy is being protected and that surveillance technology companies are not being used by governments and are not cooperating with governments selling the product so that we can be surveilled and our actions and our data can be captured and given to governments.
Hey everyone, my name is Praveen. I'm an indigenous Newar from Nepal. I have a list of questions too for Matthias because it was very concerning. You said that business owners have been jailed for speaking up. Human rights defenders like myself, we are killed every year, at least over 200 every year for the last decade. So yeah, we would really like to know how many business owners have been jailed for speaking up. We would definitely protect their human rights to speak up too. Then if businesses are having the same interests as civil society in terms of human rights, again, my question would be like, what is the stand of the IOE or the employers on the legally binding treaty for instrument on business and human rights, as well as the EU due diligence directive? Because we see that these instruments are very critical to protect human rights and bring human rights into a regulatory framework within the international human rights legal framework. So we would like to know what is the stand of the IOE and employers or the businesses on these. If I think these are built on the existing human rights obligations, so this would definitely not be objected to by the businesses. And I think the final thing is we've heard this again and again, that businesses point to states point to business, and then it's the communities that are caught in the middle and facing human rights violations for all the time. I think that should stop. So I think we need very straightforward answers, like where do businesses stand, where do states stand. So again, without chewing the words, we would really like some straightforward answers on how do you think businesses how do businesses think we should move forward on these thorny issues, particularly the treaty and the EU due diligence legislation. Thank you.
Thank you, Nicole. As I wanted to be nice and kind and grateful for our business to open the door to working with us, but I like to have some comments to the representative of IOE, and also have a question regarding to what you said about CSO asking business to speak on behalf of the LGBTIQ rights. As an LGBTIQ activist, as well as I just recently got SLAPP lawsuits against my duty as human rights defenders. My point is I like to address that in many years that companies and business try to promote LGBTIQ rights, and it's becoming a rainbow watching and pink watching, because they use it to promote that how they advance human rights in general. My point is, as an LGBTIQ activist, I like just to see how our business are being held into account for any adverse impact by their business operations. And come to my questions to you, that what exactly like LGBTIQ people asking you to speak for them, because I live under like unjust social structures where I'm greed and my people greed to share our thoughts and freedom of expressions. Instead of speaking for us, I wish that can you ensure that you speaking with us instead to ensure meaningful participations at the end. Thank you so much.
Tenemos una aquí y una.
So one